Welcome to everyone. This is Kripa Lakshmi, Assistant Professor, Department of Corporate Secretaryship, KCS Kasinadar College of Arts and Science. Now I am going to explain about members, rights and responsibilities of members, who can be a member, shareholder, contributory, difference between transfer and transmission of shares, nomination and its importance. First topic is members. In the ordinary commercial usage, the term member denotes a person who holds shares in a company. The members are the shareholders or real owners of the company. They collectively contribute the company as a corporate body. The ultimate authority in matters relating to the appointment and removal of the directors, auditors and other managerial personnel lies with shareholders. The powers of the board are also subject to the control and supervision of the general body of the members. Next topic, rights and responsibilities of member. The members of a company enjoy several rights and they are the ultimate authority in the matters of the company and its management. Their rights can be grouped under three heads. They are detailed below. First one, statutory right. These are the rights conferred upon the members by the Companies Act. These rights cannot be taken away by the Article of Association or Memorandum of Association. Some of the important statutory rights are given below. Right to receive notice of meetings, attend to take part in the discussion and vote at the meetings. Next, right to transfer the shares in case of public companies. Next, right to receive copies of the annual accounts of the company. Next, right to inspect the documents of the company such as register of members, annual returns, etc. Next, right to participate in appointments of directors and auditors in the annual general meetings. Next, rights to apply to the government for ordering an investigation into the affairs of the company. Second one, documentary rights. In addition to the statutory rights, there are certain rights that can be conferred upon the shareholders by the documents like the memorandum and the articles of association. Third one, legal rights. The rights which are given to the members by the general law. Next topic, who can become members? The company law does not prescribe any qualification which could depart a person from becoming a member of the company. It appears that any person who is competent to enter into valid contract can become a member of the company. The reason is obvious. Subscribing for shares is basically a contract between the company and the shareholders. However, the memorandum or articles may impose certain restrictions or restrain certain persons from acquiring membership in a company. In the absence of any express provision regarding the capacity of a person, the provisions of the Contract Act shall apply. As regards to certain special category of persons, the judiciary has laid down certain principles for acquiring membership in a company. They are as follows. First one, minors. A minor is not a competent person to enter into a valid contract. As such, he is disqualified to acquire membership. However, minors can be allotted shares. On attaining majority, the minor can avoid the contract, but the minor should repudiate the contract within a reasonable time. Second one, lunatic and insolvent. A lunatic cannot become a member. An insolvent, however, can become a member and is entitled to vote at the meeting of the company, but his shares vest in the official receiver when he is adjudicated insolvent. Third one, partnership firm. A partnership firm may hold shares in a company in the individual name of partners as joint holders, but the shares cannot be issued in the name of the partnership firm, as it is not a legal person in the eyes of law. Fourth one, company. A company being a legal person can become the members of another company in its own name, but a company can subscribe for the shares of another company only when it is authorized by memorandum. Similarly, a subsidiary company cannot buy the shares of its holding company. Fifth one, foreigners. Foreign national can be members of companies registered in India. For that, permission of RBI is mandatory. When he turns an alien enemy, his right as a member will be suspended. 6.1 Fictitious person. A person who takes the shares in the name of fictitious person becomes liable as a member. Besides, such a person can be punished for impersonation under Section 68A. Next, shareholder. A shareholder can be a person, company, or organization that holds stocks in a given company. A shareholder must own a minimum of one share in a company's stock or mutual fund to make them a partial owners. Shareholders typically receive declared dividends if the company does well and succeed, also called a stockholder. They have the right to vote on certain matters with regards to the company and to the elected to a seat on the board of directors. If the company is getting liquidated and its assets are sold, the shareholder may receive a portion of that money provided that the creditors have already been paid. When such a situation arises, the advantage of being a stockholder lies in that they are not obligated to shareholder the debts and financial obligations incurred by the company, which means creditors cannot compel stakeholders to pay them. Next topic, difference between transfer and transmission of shares. First, transfer. The initial transfer of ownership of the shares between the transferor, one who transfer, and the transferee, one who receives, is referred to a transfer of shares. A public company's shares can be freely transferred unless the company has a good reason to forbid it. A private limited company's share cannot be transferred as easy as a public company. Next, transmission. When a share transfer takes place because the original holder has passed away, has become insane, or is insolvent at the time, it is termed as share transmission. The rights to the shares are granted to the transferee without the execution of the transfer document, and the transmission is only recorded if the transferee provides evidence of their claim to the shares. The shares will be given to the legal representative in the event of the holder's death and to the official assignee in the event of insolvent. Next topic, difference between share transfer and transmission of shares. Next topic, contributory, which means any and all compensation payable to underwriters, dealer, managers, or other broker dealers in connection with marketing the sale of shares, including without limitation compensation payable to Inland Securities Corporation, and which may in the company's description include reimbursement for any out-of-pocket itemized and detailed due diligence expenses incurred in connection with investigating the company or any offering of securities made by the company. Next topic, nomination and importance. The nomination is a mandate given by a shareholder to give the legal title of shares to a described person with whom shares shall vest on the death of the shareholder or original holder. This described person becomes the nominee for the beneficial owner. There is a key reason behind nominations and assigning nominees. If a person dies, their investments can be transferred to their nominee. In case there is no nominee assigned, the family or legal heirs will have to go through a long and tedious process to receive the investments and assets of the deceased person. There could be a long wait and delay in receiving the process in case there is no nomination. There could have to proceed a will, certificate, or other documents providing their position. Such a situation can cause delays and strain situation for the unassigned nominee or next of kin. If a nominee is assigned, there could just need to provide the address proof, bank details, and ID at the time of claim to have the investments transferred to their name. Therefore, the investment transfer becomes very smooth and seamless. Thank you.